Hey, once again, this is on humanitarian ground, not a legal advice. But I would like Ifeanyi Ejiofor, who is the legal team of Mazi Nnamdi Kanu, to ask for a postponement on the upcoming case. So to focus on his client health. This is very important because if his client is not in good shape, both physically and psychological aspect, it will be difficult for the client to understand what is going on in the court or to understand the court procedure. And also, the International Law Commission, the ILC, and the International Court of Justice, ICJ, may be implicated in respect of non fulfillment of Nigerian state obligation on human rights, which balance the test in the provisionary norm that was adopted under the Article 33 of the International Law Commission, ILC, which was designed for state party responsibility in weighing the inconsistency interest of the Nigerian authority. As regard to the Nnamdi Kanu, who qualified for defense of necessity under the international law in accordance with the international covenant and the norm under the said Article 33 of the international law, Commission ILC, which Nigeria is a signatory with. However, Nnamdi Kanu, who was rearrested by the Nigerian authority and now in custody of Department of State Security Services, this issue of how he was arrested is now irrelevant um, because if the lawyer focused on arguing how he was arrested, they will lose focus instead of focusing on the merit of the case. Because how he was arrested is no more irrelevant as long as he still is in custody at this moment. You may recall that the Nigerian government proclaimed that Nnamdi Kanu jumped bail in 2017 following the invention of his home in Abia State and his bail condition, which was revoked on March, if I recall, March 28, 2019, and then issued a bench warrant on him. But the question here is Nnamdi Kanu defense under the international law, which is like a defense of necessity, because he acted on emergency to prevent significant bodily harm to himself on the ground that he had no adequate legal remedy at that moment. Also, whether his action was created by the danger that one would have avoided, whether it's necessary for him to take action which he took at that moment, whether Nnamdi Kanu did not contribute to emergency that led to his departure, and his life was threatened because he could not have relinquished his life for the action as he had no time to think over before his departure, or because the administrative authority escalated the course of action that led to Nnamdi Kanu's departure, which they claim that he jumped bail, even though the issue of how Nnamdi Kanu was arrested is irrelevant at this moment because he's now in the custody, as I said, and already appeared in the court and already continue the previous trial. And the question of how and the jurisdiction of arrest is not relevant at this moment. The arrest was also made possible due to lack of intelligence and the security expertise advice on his own side. because he shouldn't have, been at where he was arrested in the first place, because he fell to the trap of the Nigerian intelligence agency who have been tracking them, for the reason I will not elaborate here. Again, the success of this case will depend on Nnamdi Kanu legal team, whether Nnamdi Kanu, under the court procedure and under the FET, which depends on his lawyer, and he should also understand that his fate depends on the trial judge, and the good behavior should be of importance. And I remain Ekens Azubike, the founder of Ekens Security and Law Science and Ekens Foundation. This is not a legal advice, but it's very, very important to make an input and understand that this is on humanitarian. It is not a legal advice. It does not have anything to do with guilty or innocent. So don't forget to subscribe to our YouTube, Facebook, Instagram at Ekens Foundation. I remain the founder of against security and law science, which I said we are here to give a legal advice to anybody that needs it. Thank you very much, and I wish you a good luck. Thank